Going all right, please.
Good morning, everybody.
Good morning, Your Honor.
Good morning. Hampshire County Superior Court is now in session. Please be seated.
Good morning. Back before the court is the matter on for trial. Hampshire County Civil Action 1780 CV 0033, Patrick Buchanan et al. Versus the City of Greenfield et al.
Good morning, members of the jury. Has anything come to your attention since I last saw you here in the courtroom which has affected your abilities to continue to serve in a manner which is fair, a manner which is impartial? Seeing and hearing no affirmative responses, you may return to your deliberations. Thank you very much.
Right. All right, please.
Okay, what will this be?
For second session.
This will be used for ID, Your Honor. We're back on the matter on trial 1780 CV 0033.
Okay, we have a question from the jury that has been marked as U for ID. The question is, are we to consider / disregard / or form our own opinion on legal fees when determining damages? Okay, one moment. I'll fashion an answer that I think you'll all agree upon. All right, the answer I propose to return that will be V for ID is in response to your question marked as U for ID. The answer is you are not to consider or form an opinion on legal fees when determining damages. Any objection?
No objection, Your Honor. No, Your Honor.
I have an issue with the question because you've instructed them to about 151B that they should see if Todd Dodge had a reasonable belief that 151B was violated. There's no instruction on it, and 151B is a fee-shifting statute. And I'm concerned that they've been doing some research.
I don't have that concern. I think that jurors may legitimately, based upon their common life experience, consider the issue of attorney's fees. Any other objection to the proposed answer?
No, it's a correct answer, but as I say, I have the concern, and also the whistleblower statute is a fee-shifting statute.
I understand. If you like, I can inquire of the jurors whether or not they have done any investigation or research into the statutory authority upon which these causes of actions are based. Is that what you're requesting?
Yes, sir.
Okay, let's bring in the jury right now, and then I'll read this to them, and we'll get going. So that will be U and V.
Just on that, Your Honor, object because you have asked them every time, for the many days we've been here, and I believe they've answered.
Your objection is noted for the record. I'm going to poll these jurors. We'll do it individually at sidebar, which means I need them. Okay.
Object as well. I think there's no basis in the question.
The objections are noted. Right, let me step up a second. Yeah. Let's bring them in.
All right, please. Jury entry. Court, all right. All right. Hampshire County Superior Court is back in session. Please be seated.
Welcome back, ladies and gentlemen. Ladies and gentlemen, I appreciate your last question. Before I give you my reply, I'm going to have each of you individually come sidebar for 2 brief questions, okay? So let's call up our jurors in order. We're going to bring you up here. We're going to put on our white noise machine to make sure that no one can hear you. Please speak loudly enough so that we can hear you, but softly enough so no one else can, okay? Let's start with our first juror. Please identify him for the record.
This is juror number 4 and seat number 1.
Okay. Good morning, sir. Well, thanks for your patience. If you don't mind stepping up, thank you. In light of the last question in particular, have you done any investigation or research into the statutes that form the basis of the plaintiff's claims in this case?
Yes. I'm not sure I understand the question.
Right.
The only research I've done, I can say, is reading the guidance that. Yeah. The only research I've done is reading the guidance that you gave us.
Okay. I should have more artfully phrased it. Have you done any outside research? That is to say, have you looked at any statutes or authorities other than reference to those authorities as set forth in the jury charge?
No, none whatsoever.
Okay. All right. Very well. Thank you. You can return your seat. Let's bring up the next one.
Juror number 11 and seat number 2.
Madam Foreperson, good morning.
Good morning.
Other than the jury charge and the various answers to questions in the special verdict slip, have you looked at or consulted any statutory authorities or any other legal authorities that relate to the claims that the plaintiffs have brought, with particular regard, but not limited to the last question that was posed?
No, sir.
Okay, thank you very much. You can return to your seat. Thank you.
Juror number 19 and seat number 4.
Good morning.
Right.
Other than the jury charge that I've given you and the other written answers to questions in the special verdict slip that you have you looked at or consulted any other legal authorities, such as statutes, that relate to any of the claims that the plaintiffs have brought?
No.
Okay, thank you very much. You can return to your seat.
Juror number 33 and seat number 5.
Good morning, sir. Other than the jury charge that I've given you, the answers to the questions that have been presented in the special verdict slip, have you looked at or consulted any legal authorities, any statutes, any other materials that relate to the claims that the plaintiffs have made? No. Okay, thank you. You can return to your seat.
Juror number 46 and seat number 7.
Good morning.
Good morning.
Other than the jury charge and the answers to the questions that I've given you on the special verdict slip, have you looked at or consulted any legal authorities or any statutes that relate to the claims that the plaintiffs have brought? Okay, thank you very much. You can return to your seat.
And juror number 57 and seat number 8.
Good morning.
Good morning.
Other than the jury charge, the answers to the questions I've given you on the special verdict slip, have you looked at or consulted any legal authorities that relate to the claims the plaintiffs have brought? If you could answer, because we record.
Oh, no.
Okay, thank you very much. You can return to your seat. Okay, thank you, counsel. Okay. Since you're all here in court, I'll read your last question as well as my answer. Your question, which has been marked as U for ID, and you'll have both the question and the answer with you. Are we to consider disregard/reform our own opinion on legal fees when determining damages? My response, which is V for ID, in response to your question marked as U for ID, the answer is you are not to consider or form an opinion on legal fees when determining damages. You'll have both of these documents with you. You may now return for your deliberations. Thank you all. Okay.
We're now back in session.
Okay. All right. The jury requested a clean copy of the special jury verdict slip. I want to make sure that the special jury verdict slip that goes to them is the same that they currently have. I've reviewed it, and it appears to me to be so. So what I'm going to do is, let's see, Melissa, which is the one that you want to hand them? One of these?
One of those.
Okay. First Assistant Clerk Duran will have you review it. The only question is this the same verdict slip? That's the only question. Presuming the answer is yes on for each of the parties, that'll go immediately into the jury room. Any drafts of any jury verdict slips, I'm going to advise these jurors are part of their notes, which are confidential and are going to be destroyed, and no one will ever see them. Okay? Did you have a question, Attorney Ryan?
No, Your Honor.
Okay, very well. Why don't you take a look at these documents, that one document right now? As I say, the only question is this the identical one? I've looked at it, and to my eye, it is. Melissa? Should the court officer tell them that they all jury verdicts should go in with their notes to be destroyed? Or? Yeah, or I'm just saying, as opposed to you're telling them.
Yeah, I think that's probably what should happen when we go in.
Yeah. Yeah, okay, well, and then I'll, yeah, why don't you tell them that, okay? Okay, and let them know that as with any other note, it's confidential, no one will ever see it, okay? All right, so Attorney Ryan, Attorney McDonough, are you satisfied that is the same special verdict slip?
We haven't gotten it yet, Your Honor.
Oh, I thought there were two copies, okay, I apologize.
No, sir. Just fine.
Okay, Attorney Keston, is it the same?
Yeah, it appears to be yes.
Okay, thank you, sir.
Yes, Your Honor, it appears to be the same.
Okay, Attorney McDonough, you're satisfied?
Yes, Your Honor.
Okay, great, it'll go to the jury, please.
Buchanan et al. Versus the City of Greenfield et al.
Yes, we have.
If you could please give the verdict slips to the court officer.
Thank you. Madam Lady Clerk, you may record the verdict.
Thank you, Your Honor. Madam Foreperson, hearken to your verdict as the court will record it in Hampshire County Civil Action number 1780 CV 0033, Patrick Buchanan et al. Versus the City of Greenfield et al. Question 1. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that the city of Greenfield discriminated against him because of his race in connection with a promotional process that occurred between September 2014 through October 2015? Answer, yes. Question 2. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that the city of Greenfield's failure to promote him from the short list in 2014 was motivated by racial animus? Answer, yes. Question 3. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that Chief Haig initiated the internal investigation regarding the traffic stop in 2015 because of racial animus? Answer, no. Question 4. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that the 3-day suspension that Chief Haig imposed as a result of the 2015 internal investigation was motivated by racial animus? Answer, yes. Question 5. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that Chief Haig gave him a letter of reprimand as a result of the 2018 Al Donovan investigation as a result of racial animus or retaliation? Answer, yes. Question 6. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that the city of Greenfield discriminated against him or retaliated against him in connection with the 2020 to 2021 sergeant's promotional process? Answer, yes. Question 7. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that Chief Haig discriminated against him or retaliated against him in connection with the 2020 to 2021 sergeant's promotional process? Answer, yes. Question 8. What amount of damages do you award to compensate Patrick Buchanan fairly for the discrimination or retaliation that you have found the defendants to have committed against him? Any damages you award related to the period September 2014 through October 2015 as set forth in questions 1, 2, 3, and 4 are limited to one amount for such period. Answer, lost back wages, $92,930.00. Emotional distress. Answer, $350,000.00. Question 9. Did the plaintiff, Patrick Buchanan, prove by a preponderance of the evidence that he is entitled to an award of punitive damages against the city of Greenfield? Answer, no. Question 10 has gone unanswered. Question 11. Did the plaintiff, Todd Dodge, prove by a preponderance of the evidence that the defendant, city of Greenfield, retaliated against Mr. Dodge in violation of the Massachusetts whistleblower law? Answer, no. Question 12 is unanswered. This is the verdict of the jury. So say you, Madam Foreperson. So say at least 5 of the 6 members of the jury.
Yes.
Thank you.
All right, you may be seated. Counsel, I will have the completed special verdict slip shown to you now by Officer DeRoche, if you'd be so kind, just to show it to counsel. If counsel wishes to be heard at sidebar relative to any scrivener's errors that you believe might exist therein, limited to such, please approach sidebar. All right, thank you. If any counsel wishes to be heard at sidebar, seeing none then, ladies and gentlemen, I wanted to publicly acknowledge your service on this jury. When we impaneled, we advised you that this trial was slated to go to the jury 2 weeks ago. And mindful that we did have a hiatus, and we go half days here in Northampton. Here you are 2 weeks later. I cannot perhaps overstate my gratitude for your service in this particular case in bringing this case to verdict today. I'm going to join you in just a brief moment to express my personal gratitude. So for that purpose, I'll ask you to return to the jury deliberation room, but then I promise you'll be out of this building for at least another 3 years in very short order. So once again, I publicly acknowledge and thank you. I'll see you shortly in the deliberation room. All right. I'm just simply going to give you a schedule for the filing of a motion for attorney's fees and costs. I think 2 weeks would be appropriate for the filing and service. You may have 2 weeks thereafter if you wish for your opposition. I'll schedule a hearing accordingly thereafter, okay? It'll be by Zoom, okay? Any other motions pursuant to Rule 50, Rule 59, whatever else have you, counsel can certainly file pursuant to rule, and I will set a schedule for briefing and hear them in a manner that is convenient for all counsel.
It's 10 days from the entry of judgment, right?
Of judgment.
Right, entry of judgment.
That's correct, right.
So is it, in your view, is it from the final judgment after attorney's fees?
Final judge, yes. Yeah,
Okay,
judgment's a term of art, and that's why I reflect on that. It's not the verdict.
Right.
It's there won't be a final judgment. We used to call it final judgment. I'm not sure if we actually have that word final there, but until the award of attorney's fees. So the judgment won't enter until I consider and rule on the motion for attorney's fees. At that point, I'll direct the court to enter final judgment, and that will be the judgment for purposes of JNOV and new trial.
That's why I raised it because some courts enter judgment on the verdict, and then you get nervous. So if we're all clear that it's 10 days,
absolutely, yes, yeah. The
you'll
judgment
have it sooner than that, but sooner than the 10 days.
Yeah, no. We do things strictly under the letter of the rule. And I appreciate your raising the issue because many incorrectly believe it's the verdict. It's not, okay?
No, I understand, but as I say, but also some courts, as I say, just enter the verdict as it then enters as a judgment, and we all get nervous.
Okay.
Got it.
All right. Anything further, Attorney Ryan?
No, Your Honor.
Attorney McDonough?
No, Your Honor.
Attorney Keston?
See you in October.
It's
2023.
Well, actually, that would have been if there were a mistrial. By the time this case gets back here, if it does, it will be far beyond October of 2023.
No, but I anticipate you.
Yeah. It may be 2024 or 2025, if indeed that is the result. Let me just state to the parties, to counsel, I first came aboard this case for trial. To say that this case has been hard fought is a gross understatement. I respect, as I think Attorney Keston honestly and confessively pointed out to the jury that these, or at least to the court, that these are emotional matters, especially where parties continue to work together in such important positions, positions of honor. So, having said that, and despite our ups and downs and downs and downs and then up, it has been my distinction to work with all of you. I look forward to continuing our rulings for the motions that I've identified. With that, I wish you well. Stay healthy.